Good morning and welcome to the Justice Committee's 11th meeting of 2020. We have apologies from Liam MacArthur and Rona Mackay, and I welcome Bill Kidd as Rona's substitute. Agenda item 1 is a decision on whether to take item 8 on our work programme in private. Are we all agreed? Yep. Thank you. Agenda item 2 is consideration of an affirmative instrument, Civil Litigation, Expenses and Group Proceedings, Scotland Act 2018, Success Fee Agreements Regulations 2020 draft. And I welcome Ash Denham, Minister for Community Safety, and her officials, Hamish Goodall, Civil Law and Legal System Division, and Heather McClure, Legal Directorate with the Scottish Government. I refer members to paper 1, which is a note by the clerk and includes submissions received from stakeholders, and invite the Minister to make a short opening statement.
Thank you. Good morning, Convener, and good morning to the committee. These regulations will, for the first time, regulate the use of success fee agreements in Scotland. Success fee agreements, and particularly damages-based agreements, are sometimes referred to as no-win, no-fee agreements, whereby the client pays nothing if a claim is lost, but pays a percentage of damages achieved to the provider of relevant services if the case is won or settled. Success fee agreements can be used as a means of financing a wide range of civil proceedings, but they're most commonly used in personal injury cases. The vast majority of personal injury claims are now financed in this way rather than being legally aided, and success fee agreements represent a major contribution to access to justice, particularly for people who may not be eligible for legal aid and may not be able to finance a claim in any other way. Although damages-based agreements based on a percentage of the damages achieved have been in use for some time, solicitors have not until now been able to offer such funding to clients. They've been used by claims management companies, some of which are owned by large firms of solicitors. Section 2 of the 2018 Act now permits solicitors to offer such funding, thus increasing competition. And I would draw your attention in particular to Regulations 2 and 4. Regulation 2 sets out caps on the success fee which may be charged under such agreements, and this is to make the cost of litigation more predictable, thus increasing access to justice through a more accessible and a more affordable means for people to enforce their legal rights. And the levels of these caps on success fee agreements are those which were recommended by Sheriff Principal Taylor in his review of the expenses and funding of civil litigation in Scotland. Regulation 2.6 makes it clear that only one success fee may be charged, and Regulation 4 sets out what must be contained in success fee agreements in Scotland. Regulation will also be provided by professional rules of the Law Society of Scotland for solicitors and the Financial Conduct Authority for claims management companies. General consumer protection legislation will also apply. For example, a cooling-off period will apply under the Consumer Contracts Regulations of 2013. The proposed regulations on success fee agreements are intended to be relatively light touch, and the intention is that the regulations will ensure that the potential costs are clear to would-be litigant and that such persons are comparing agreements which are broadly similar. And I recommend these regulations to the committee.
Thank you, Minister. Before I ask questions from members, I wonder if you could clarify in your opening statement, you said claims companies, which could be companies composed of solicitors, were the only ones that, if I picked you up rightly, that operated no-win, no-fee, whatever, arrangements. Is that strictly true?
So claims management companies are the majority of them. So they operate them. They're often owned by firms of solicitors themselves, but they are the ones that are operating the damages-based agreements at the moment.
All right. So is it your position then that no individual firms...
solicitors are not, until now, would be able to offer these arrangements? That's right.
So none of them have up till now?
No.
Okay. Questions from members? Liam Kerr.
Thank you, Convener. Good morning, Minister. For full transparency, I'll declare an interest up front as a solicitor with a current practicing certificate in England and Wales and Scotland, and as an employment law specialist representing in employment tribunals. Minister, You've previously told Parliament that the Scottish ministers are committed to a principle of 100% compensation for people who have sustained life-changing injuries. Now, given that as a premise, how do you justify a success fee which takes part of the compensation, particularly for future care, future loss, and gives it to the solicitor as a bonus?
Well, Sheriff Taylor obviously did consider an approach. I wonder if you're specifically asking about the sort of the future loss element as being part of that, and that success fees will come out of the future loss payment. So Sheriff Taylor did consider that approach, and obviously that was part of a careful consideration that went on for about 2.5 years. And the approach that Sheriff Taylor has advocated is the one of the sliding scale, primarily for its simplicity. So we know that most cases, if they don't make it to court, it'd be quite difficult, I think, to separate out the heads of loss within that. In fact, I don't believe that's commonly done.
But it could be
so
done.
It could be, but it isn't at the moment. And of course, 95% of these actions are at the moment settled out of court. And when that is done, then obviously periodical payments are an option. And if periodical payments are included in the arrangement, they are automatically excluded from a calculation of the success fee.
Forgive me, Minister, because I'm not sure if this answers the question, and I will come back to the periodical payments, if I may, in a second. But let me just phrase the question a different way. As I understand it, an injured person solicitor is already getting paid for the time spent on the case and the expenses that they incur. They can then apply for an additional payment of judicial expenses, and I believe the court usually awards more than 100% of their costs. Now, given that, if again that premise is correct, how do you as a minister justify a further payment being taken from the injured person's compensation award and given to the solicitor as a success fee? And secondly, what evidence is there that a financial incentive is required to get solicitors to take on such cases?
Well, Sheriff Taylor considered all of those points, but to address the one about the additional payments, our understanding of that is that only applies in about 5% of cases. So I think that's a very, very small amount of cases. And, you know, it's unlikely that a lump sum of less than £500,000 would include an element, you know, of this future loss, if we're looking at it like that. And if, of course, if it's over the £500,000 fee, then it is restricted to 2.5%. So just to put this into context, at the moment, this is completely unregulated. So there are claims management companies out there. We know of examples where they are charging 25% fees, even up to 33% fees. So this is simply a regulation of that. And if I can just give the committee an example of how this will work if these regulations are enacted. So if we take an award of £1 million, so let's say that was a result of, for instance, criminal negligence, currently, clinical negligence, currently a fee from a claims management company might be of the order of about 20%. So that would be a fee of £200,000. So under these regulations that are in front of you this morning, they would receive a maximum amount of £72,500. So you can see that's quite a considerable difference. So that is applying, obviously, the sliding scale to the fees.
Forgive me, Minister, because I think this is in the papers. It is important information, I accept that, but I think it's in the papers. And the question, because I do want to ask about the periodical payments order, but do you have any evidence that a financial incentive is required to get solicitors to take on cases, especially over £500,000? Is the evidence there?
Well, my understanding is that Sheriff Taylor did consider that, and he did think that was a factor. But I'll let Hamish see if he can add a little bit more detail to that for you.
I think we're looking at this from the wrong side, incentivize. You've got to look at it from the point of view of the client. Unless you've got a lot of money yourself, you're not going to be able to raise a personal injury action. So the provisions of the bill will put, at the present moment, the insurance industry have told us that if you suffer a catastrophic personal injury, you will have no difficulty finding a solicitor or a claims management company to take that claim forward. Because if it's catastrophic personal injury, there will be a big damages payment, and therefore the payment to the provider of the relevant services will also get a big fee as well. If a party is not at the other end of the scale, if someone is eligible for legal aid, they will be able to finance their personal injury claim through legal aid, although legal aid financing of such claims now is very rare. The vast majority of personal injury claims are now being financed by success fee agreements, damages-based agreements. And it's what Sheriff Principal Taylor called the excluded middle. People who are not eligible for legal aid, who may not be able to raise an action, so they need to have some other means of being able to finance that action, and that's what the success fee agreement does. Now, Sheriff Principal Taylor spent 2.5 years coming up with these success fee caps. And his view is that they represent a fully considered compromise. He had a policy advisory group advising him with representatives from both the insurance industry and insurance lawyers, and also personal injury solicitors. And the caps that they came up with are a fully considered compromise. They think they're fair to everyone. And it's intended that not only will the client get the vast majority of damages that are claimed, but the solicitor will also get a reasonable return on the risk that they are undertaking. You might be interested to know that one firm of solicitors told us that when they were raising a catastrophic personal injury case on behalf of a client, their outlays in the case were £175,000. Therefore, in order to be able to exercise that person's legal rights, the solicitor is going to have to get a reasonable return on their outlay. So, I mean, I think it's very rare in any jurisdiction in the world for a pursuer to get 100% of their damages, because they've got to pay for their legal advice. So even although you will get your damages from the other side based on the law, you still have to pay your lawyer. Therefore, you're not still going to get the 100% of what you were awarded or agreed upon in a settlement.
I'm in here because I'm aware that a lot of the members were not members of the committee when we looked at this thing, and I notice you've made no reference to the committee's scrutiny of this legislation, and it's a very distinct and firm recommendation that should damages for future loss, and future loss is to cover the expenses that an individual has because of something that has happened. It could be for their physical care, for the mental care, for various things. So future loss, the committee was absolutely solid on that they should be protected. And if they aren't going to be ring-fenced, and this SSI says they are not going to be ring-fenced, then the committee considers, and this is straight from our Stage 1 report, that the court must have the power to make periodic payments, and these, you have said, will be protected, and for good reason, because it's future earnings to safeguard your well-being. And we understand at that time, and we're going back to December 2017, that the committee notes the Scottish Government intends to introduce such a power in its forthcoming damages bill, and that the committee considers the provision of the bill should not be brought into force until such time as the court has the power to make the periodic payment order. Now, that bill has passed, but Part 2, which gives the power to make these periodic payments, has not been brought into force. So it seems to me quite quite outrageous, really, that we should have an SSI before us today that doesn't ring-fence these future earnings, and that the government hasn't taken the steps that it easily could, because the legislation is waiting to be enforced, to protect them through the introduction of periodic payment orders.
Okay. I think the convener makes a good point, which I totally take on board. There's a couple of points that I would make in reference to that. So the first is, as I stated before, 95% of personal injury actions, and that covers you know, a majority of what we're discussing this morning, do not make it into the court doors. And so periodical payments are still available as an option to them, which would obviously not be then included in the success fee. And the convener is also right to say that the periodical payments was included in the damages bill of 2019, and that it has, and you're right to say that it has not yet been enacted. But of course, that is a matter for the Scottish Civil Justice Council.
Could you explain that further then?
They are developing their rules of court. And as they're working through this in a sequential basis, and unfortunately they have not given us a time frame as to when they expect to conclude that work.
Can I ask what the representation the government has made, given they're in a position where they're not approving these being ring-fenced? And is it acceptable then that there has been this delay? What communication has there been with the Civil Council?
I'm afraid we're unfamiliar with what steps have been taken in relation to the commencement of that act, but it's worth making the point that in relation to personal periodical payment orders, they are will now only be able to be made by a court, but only 5% of personal injury actions
I think
actually
you have made that point quite forcibly, but the point is you're coming to committee today asking this committee to approve not ring-fencing these very important future earnings, and it seems no attempt has been made to find out why there has been delay in implementing Part 2 of the damages bill, which would have solved the problem.
So my understanding of it is that the Scottish Justice Council have a pressure of work, and they are working through that workload in a sequential basis, and they have not updated us and given us a date as to when Part 2 of damages will be enacted.
But the government hasn't formally written and expressed some concern about this.
Well, they prioritise their own workload, and they work through that at their own pace.
Can I remind the Minister the reason that we're bringing in these is to protect this 5% who are currently vulnerable, and that does seem unacceptable to me, John Finney.
Thank you, Convener. Good morning, Minister. Good morning, panel. This piece of legislation was one of the most complex that I think I've dealt with in my time, and we're not here to revisit it, but we are here to deal with some of the consequences of it. I wonder, Minister, if you're cited in the evidence that the committee has received, for instance, from Thompson solicitors, who say, in general, excuse me, Thompson solicitors fully support both the policy objectives and drafting of the regulations. They then raised two specific points I wonder if you could comment on, please. That is the implications for the solicitor if part of the claim is pursuit of a criminal injuries compensation claim, and the implications that has for fees. And the other aspect that they raise concerns about is in the circumstances where a client changes solicitor and how, if you like, the fees are divvied up thereafter. Could you comment on both of these, please?
Yes, so in terms of, you know, as you've described, where perhaps a client has one solicitor who does some work on the case, and then for whatever reason, maybe the client decides to, or maybe the solicitor decides not to proceed, and then eventually with another provider, the claim goes on to become successful. That is part of these regulations, ensure that the client will only ever pay one success fee. Even if there is more than one provider, they will only ever pay one success fee. That's a very important principle of these set of regulations. In terms of the cap in respect of criminal injuries, yeah, it's not covered under this, because these regulations just refer to civil litigation proceedings.
Okay, I wonder, could I maybe just press you a bit further, Minister, on the first point, and that is where there's a change of solicitor, and the suggestion, which seems not unreasonable, that each firm receives a fee proportionate to the amount of work they've contributed to in the overall work to bring the matter to a successful conclusion. Do you feel that that's adequately covered, or is there a gap there in provision?
Perhaps I could reply on that one. At the present moment, we understand that it's quite common to include clauses in damages-based agreements whereby if a first provider has concluded that a claim is not going to be successful and withdraws, and a second provider of relevant services is actually successful, it may be that, but only if the case is successful, the client will be liable to the first provider for some of the outlays on the case. Now, we don't think this happens very often, because, you know, if one firm of solicitors thinks that the case is not going to be successful, it's not going to happen very often that a second provider is going to be successful. We are not aware of these kinds of provisions causing any difficulty at the present moment. We did actually consult on this when we did a consultation over the winter of 2018-2019, and the responses to the consultation were very much mixed between those who thought these things should be banned and those who thought they were quite fair, because it may well be that the first provider has actually done a lot of work on the case and has actually contributed to the ultimate success of the case, albeit the ultimate success was achieved by another provider. So we've decided not to put anything in the regulations on this at present, but of course post-legislative scrutiny on the legislation is due in 3 years now. So if at that time any evidence appears that such arrangements are causing difficulty, then we can come back and address it then.
If I may, I was going to ask about that, because of course it's only in the light of experience of operating these regulations that some of this, but the government would be minded to consider addressing these issues if it became...
well, if the evidence appears that they are causing difficulty, but as I've said, I don't think these kinds of cases arise very often.
Okay, thank you very much.
Liam Kerr.
I'd just like to come in, thanks, Convener. I want to address the point that the Convener makes, but I'll come at it from a slightly different angle, Minister. So the success fees only apply when the injured person opts to take a compensation payment as a lump sum. They don't apply, and therefore the compensatory award is not reduced if it's taken as a periodical payment order. Now, that means that if a solicitor advises their client to take a lump sum award, then that solicitor is going to benefit from the success fee payment. Now, Sheriff Principal Taylor, whom you referred to, told this committee that he recognised that this could create a potential conflict of interest for the solicitor. So the question begged is the Minister comfortable with building an inherent conflict of interest into the system, and shouldn't this be delayed, following from the Convener's remarks, until the Part 2 is brought in?
Okay, I think you may be conflating several areas there, but the solicitor, in the event of a settlement of over 1 million, the solicitor will be required to obtain either the approval of the court in the case of the award, or a report from an independent actuary in the case of settlement, certifying that it is in the best interest of the pursuer that the damages should be paid by way of a lump sum rather than by a periodical payment, before the solicitor will be entitled to be paid a success fee from the future loss element of an award of damages. So that is built in there in order to address the issue that Mr. Kerr has raised.
I'm not sure I followed that, Minister, if I'm honest, and it may be, forgive me, I'm slightly deaf in one ear today, so I may not have heard correctly. But isn't there a risk, as Sheriff Principal Taylor identified, that we build an inherent conflict of interest into the system? for the solicitor who is advising on whether to take a lump sum payment, which will yield a success fee, or a periodical payment order, which would not.
Indeed, and that's why Sheriff Principal Taylor has advised that they will be required to get a report from an independent actuary to make sure that the lump sum is in the interests of the pursuer, and that it wouldn't be better for this to be made in terms of a periodical payment. So I think that surely goes some way to address the members' concerns.
Potentially. Let me ask the second part of that question again then. Is there not merit, as the convener I think was suggesting, in delaying what we have before us today until, so I heard the representations from Hamish Goodall about there's another agency to whom you appear to be beholden. Wouldn't it be better to delay this until part 2 is brought in?
Well, I suppose the way I'm looking at it is in the wider context, and that if claims management companies are currently, and their fees are completely unregulated, in my opinion, it is better to pass these regulations so that they may be regulated, so that the caps will come into, the caps will then be enacted, and the amounts that solicitors or claims management companies are receiving will be subject to the caps. It will be transparent, it's simple for everyone to understand, and it will mean that some of these success fees will be brought down to a more reasonable amount.
Thank you.
Perhaps I could add to that. There are two problems with civil litigation at the present moment. The first is people fear what they're going to have to pay their own solicitor to pursue their case. The other problem is they fear what they might have to pay the other side if they lose the case. So part 1 of this Act on success fee agreements, that addresses the first problem. Success fee agreements and the caps thereon make it predictable what you're going to have to pay your own solicitor to pursue your case. Part 2 of the Act, which is waiting for rules of court from the Scottish Civil Justice Council, that will provide qualified one-way cost shifting, which means that even if you lose your personal injury action, you will not be liable for the costs of the other side, because the other side is likely to be a large, well-resourced insurance company, whereas you are Joe Public.
James Kelly.
Thanks, Convener. I want to follow on the points, the line of questioning that John Finney was pursuing in relation to the Thompson's submission, particularly around success fees. As I interpret it, it looks as if there's an inconsistency in approach. In terms of success fees for criminal injury compensation, in relation to solicitors' fees, where a success fee applies, they can only be recovered from part of the client damages, whereas in all other personal injury cases, the part of the solicitor's fees can be recovered from the compensator itself. So there seems to be an inconsistency in approach there.
So this legislation is only concerned with civil litigation and not anything to do with criminal compensation. So it doesn't seem to be the appropriate place to make any provisions regarding criminal injuries compensation.
Sorry, I was just going to add, Sheriff Principal Taylor did not consider criminal injuries compensation in his report, and the convener will recall that there were 6 evidence sessions on the bill, and it was never raised during those 6 sessions.
This is civil litigation the bill was referring to, so the claims are all civil. Minister, you just said if we pass this SSI, then some success fees may be brought down to a more reasonable amount. But the point is, because the regulations have not been passed by the Civil Justice Council, they've delayed in it, then these future earnings are vulnerable if a lump sum is paid. And there is a potential conflict of interest that solicitors are then taking their fee out of these future earnings if they advise their client to take a lump sum. So what I'm asking today, would you consider going away, looking at this again. It doesn't have to be passed until 29th of March, and it seems entirely reasonable that you would go back to the Civil Justice Council, find out what the reason for the delay is, because they are in a position to pass the legislation which will allow the court to make periodic payments which protect these very valuable future earnings from vulnerable people who need to be assured the full amount can be put to the purpose they were intended to. So can I ask the Minister to delay this for a week, go back, look at it, and the committee can decide it and look at it again. But at least we have the reassurance of knowing absolutely everything has been done to try and get what should be happening, and that is Part 2 regulations for the damages brought in to allow periodic payments and, crucially, to protect these future earnings.
I understand what the convener is saying, and I can see the convener is very concerned about this issue. I would reiterate that I feel that the concerns raised by the committee are only applicable to about 5% of cases, which is a very small amount. I would also say that obviously the Scottish Civil Justice Council is not accountable to Scottish ministers, so I think that's an important point to make clear as well. And that obviously Sheriff Principal Taylor and his policy advisory group, looked into this matter over a number of years, with both sides of the argument being involved in this. It's fully considered compromise on the fees, and I would say that implementing this cap will be very, very beneficial, and this is an access to justice issue.
The committee also scrutinised everything that was done under Sheriff Principal's, the Sheriff Taylor's recommendations, and I will remind the Minister there was a considerable delay in when he first made these recommendations to us ever getting anywhere near looking at them. And while this may provide more protection, it doesn't provide anything like the protection that should be coming from the solution that this committee recommended, which would allay its fears when it passed its Stage 1 report all the way back in December 2017. So while the Scottish Justice Council is not accountable to the Scottish Government, I do not think it's unreasonable that the Scottish Government, given this 5%, it may only be 5%, but that's individuals that need this money. So I don't think to quantify it as only 5% is really a legitimate argument for not going back, double-checking and seeing if there is a reasonable explanation for why these regulations cannot be brought into force sooner rather than later. So I again ask the Minister to reflect on that. Are there any other comments? Liam Kerr.
May, Convener, just entirely for my clarity, if you would, Minister, so you said this only applies to 5% of cases, and this is a very small amount, and I see that if it's 5% as against 95%. Are you able to put any flesh on that? How many cases are 5% of cases? Like, how many cases are we talking here, and what's the financial value of those 5%? Is that information available?
I'm not sure that information is available. Hamish, do you have anything on that?
No, I don't. But the fact is that at the present moment, 95% of cases, in 95% of cases, personal periodical payment orders are available if the parties agree to them. It's only if it goes to a court. At the present moment, a court does not have the power to impose a periodical payment order. That's the change made in the 2019 Act. So you can have periodical payment orders at the present moment, and apparently the NHS are very keen on paying out damages by that method. Can I also mention in relation to lump sum payments, Sheriff Principal Taylor basically didn't make any differentiation between lump sum payments for past loss or for future loss. He thought the system should be as straightforward as possible. Therefore, if it's paid in a lump sum, then it will be liable to the calculation of the success fee. He pointed out that very often settlements are made at the door of the court, And if they're made, you know, there'll be broad brush settlements, and the parties almost certainly will not distinguish between past loss and future loss. Therefore, and if we were to change that situation, then there may be satellite litigation between the solicitor and the client, depending, because the client will say, if it was made the case that you couldn't have a success fee on future loss, and there was a settlement at the door of the court, there may be argument between the client and the solicitor about which bits should be liable to the success fee. Sheriff Principal Taylor's rationale was that it's much more straightforward if you make it that all of the lump sum is liable to the success fee, but in cases of more than £1 million, the solicitor will require to obtain either the approval of the court or a report from an independent actuary that it's in the best interests of the pursuer that the damages should be paid by way of a lump sum rather than periodical payments. And that's in section 6, 4 to 8 of the bill, of the Act, rather.
Fulton.
Thanks, Convener. I'm not sure, Convener, if you're proposing that we put this off today or go to vote, but I would just want to say if the Minister remains minded to put it forward, I'm happy to vote for it. I feel reassured by what the Minister's already said. It is an access to justice issue. I think that the concerns around it have been articulated very well by yourself, Convener, and by Liam Kerr. I'm pretty sure that they'll be taken on board, and we've already heard that there's post-legislative scrutiny built into the Act anyway. So, in my view, this is an access to justice issue. We've already heard there's been delays. I would think that we should be going ahead and making sure that the vast majority of people are getting this.
Right, are there any more views from the committee? If we've exhausted it, I think we move now to the formal consideration of the bill. Agenda item 3 is formal consideration of the motion in relation to the affirmative instrument. The Delegated Powers and Law Reform Committee has considered and reported on the instruments and has no comments. The motion will be moved with an opportunity for formal debate if necessary, and the motion is S5M-21029 that the Justice Committee recommends that the Civil Litigation Expenses and Group Proceedings Scotland Act 2018 Success Fee Agreements Regulation 2020 draft be approved. Minister, to move, and do you wish to speak to the motion, Minister?
Moved.
Okay.
Convener.
Do members have any questions or comments? John Finney?
Thank you, Convener. Yes. I think, and I don't know how many around this table were involved in the discussion, this was a very complicated piece of legislation, and I don't think the intention of the proposal we have in front of us today was to revisit the merits of that legislation. We are where we are in relation to it. I raised 2 concerns which I'm happy will be picked up subsequently, and to say again in relation to the quote I read out from Thompson's solicitors, fully support both the policy objectives and drafting of the legislation, of regulations, I beg your pardon, and also in relation to the Law Society who made a submission, a 4-line submission, the last 2 lines of which are the regulations produced are designed to provide clarity to the profession and protect the public interest. So I'm content that we move and vote on it today.
Thank you, Mr. Finney, for that comment. Just before we move on, can I confirm that the 95% that do not come to court are very unlikely to use periodic payments as settlements? Is that the case?
No, I think they'd be more likely to use periodical payments as settlements.
And the basis for that is?
It just has to be agreed between the... Well,
the officials are not allowed to speak at this point, is that correct?
That's correct, yeah.
It's just a matter, my understanding is, of an agreement between the parties as to what is the most appropriate type of settlement.
Right. Any other members want to speak? I'm sufficiently concerned that the checks and balances are not here, and rather than helping improve this situation and to safeguard future earnings, I've asked the Minister if she would consider delay, and I think that's in, you've indicated that would not be the case, Minister. Well, in these circumstances, I regret that I certainly would be voting against it, and therefore the question is that Motion 21029 in the name of Ash Denham be approved. Are we all agreed? And the answer is no. Those in favour, please show. Those against, please show.
6 in favour, 2 against.
6 in favour, 2 against. Therefore, the necessary legislation SI is passed. And is the committee content to delegate to me the publication of a short factual report on our deliberations? Thank you for that. I thank the Minister for attending today. Spent briefly for a change of witnesses. Agenda item 5 is consideration of a negative instrument, Police Pensions Amendment Scotland Regulations 2020, SSI 2020/33. I refer members to paper 2, which is a note by the clerk, and ask if members have any comments on this SSI. John Finney.
Thank you, Convener. I wish to refer people to my register of interest. I'm the recipient of a police pension, and although I don't believe any of the provisions will have any implications to myself, I think it's important to put it on the record.
Okay, duly noted. Are there any other questions or comments from members? Are members content not to make any recommendations to the Parliament on this SSI? You are. Thank you. Our next item of business today is the report back from the Justice Subcommittee on Policing's meeting, which took place on the 12th of March 2020. I refer members to paper 3, which is a note by the clerk, and invite John Finney to give this report.
Thank you, Convener. As you say, the subcommittee met on the 12th of March when it held an evidence session on the Policing the United Nations Framework Convention on Climate Change 26th Conference of Parties Climate Summit, also known as COP26. The conference is to take place from 9th to 20th November this year at the Scottish Events Campus in Glasgow. Assistant Chief Constable Bernie Higgins and James Gray from Police Scotland provided comprehensive details of the planning and preparations for policing the conference. ACC Higgins provided a reassurance that progress had been made on three key areas previously highlighted with the Chief Constable as a concern, namely funding, governance and risk. Police Scotland are working on the principle of no financial detriment to the service, which has been accepted by Peter Hill, the Chief Executive of COP26. The UK Government has confirmed that it will provide marginal cost recovery, which includes the cost of mutual aid from other UK police forces and associated costs such as accommodation. The most recent cost estimate for policing the event is £180 million, which is reduced from an initial indicative cost of £250 million. This will be reviewed on an ongoing basis and is subject to independent verification by the Metropolitan Police Service. ACC Higgins outlined the governance arrangements in place and provided an assurance that police unions and staff associations are included in the planning process. There is a contingency planning for risks, and the potential risk of the spread of the coronavirus is included in that planning. ACC Higgins outlined the scale of the event and a number of the particular challenges. On the issue of peaceful protest, ACC Higgins confirmed that Police Scotland do not classify climate change protesters as a terrorist threat, but simply as climate change protesters. This is one of the largest conferences ever to be held in Scotland, and this subcommittee will therefore keep the policing aspects under review.
Thank you. Do members have any comments? Okay, thank you for that report. Agenda item 6 is an evidence session on the newly introduced Defamation and Malicious Publications Scotland Bill. And this is an opportunity for us to find out more about the purpose of the bill, which we will scrutinise over the coming weeks. And I welcome the Scottish Government's bill team to the committee, Jill Clark, Head of Private Law Unit, and Joanne Tinto, Solicitor, Scottish Government Legal Directorate. I refer members to paper 4, which is a paper from the clerk, and paper 5, which is a private paper, and invite both either Joe or Jill, whoever wants to start, to, if you wouldn't mind, give us an overview of the bill.
Okay. I think you're probably aware of a bit of the background to it because you have taken some evidence from the Scottish Law Commission, but it emanates from a Scottish Law Commission report, which was published in 2017, and that was carried out in response to their 9th call for evidence for their 9th programme of law reform, where they got quite a few people suggesting that this was an area of law that was ripe for some reform. So the rationale for reform is that although defamation litigation has not been particularly common in Scotland in recent years, societal changes such as the increased use of internet communication means that there's more scope than ever for speedy and potentially unfair damage to reputation. So their report proposes changes to the law, which are generally in line with some changes that were made in England and Wales following the commencement of the Defamation Act in 2013. So it introduces a requirement that a right to bring defamation proceedings only accrues if the publication of the statement is to a third party and the publication has caused serious harm. It puts on a statutory footing the principle laid down by Derbyshire County Council v Times Newspaper Limited, that a public authority has no right at common law to bring proceedings for defamation. It puts the common law defences of veritas and fair statement on a statutory footing, and it replaces the common law of verbal injury with 3 statutory provisions on malicious publication, and changes the 3-year limitation period to 1 year. The Scottish Government did carry out its own consultation following the publication of the report, and as a result of that consultation, 3 additional issues have been included, which is a definition of defamation, making unjustified legal threats an actionable delict. A definition of defamation, tightening up on the narrowing of the editorial activity, and also a provision allowing parties extra time to engage in alternative dispute resolution within the new limitation period.
Thank you very much. That's helpful. It's legislation I think the committee was quite keen to see come into force. We felt that there was a need for that, for investigative journalism, for online publication, for a number of reasons. We felt that Scotland was lagging behind. It was time to look at that, so we were pleased to see it. Can I ask maybe, and start with the question of how it was determined that the limitation would move to 1 year when it was previously 3 years, you know, a period where an action could be brought?
Yes, I mean, at the moment it's 3 years, and there's also discretion to extend that to, you know, for good reason. The court has that discretion. The recommendation to move to 1 year was contained in the Scottish Law Commission's report, and really it was based on the fact that 3 years is quite a long time for a defamation claim to manifest itself, because if you've been defamed or harmed by it, it's going to probably come to light fairly quickly. And so therefore, moving to 1 year was more consistent with other jurisdictions as well. And we're following that recommendation.
Okay, thank you. Alistair?
Thank you very much, Convener. It was really just to ask if you could elaborate a bit more about what I think one of the aims of the legislation is, which is to introduce new remedies, or to reflect the fact that perhaps in the past there haven't been as many remedies available in Scotland as there have been in England. So can you say a bit more about what was intended there?
Yes, I mean, currently in Scots law, the usual remedy is damages, so you can get compensation if you've been defamed, and that's really it to an extent. So what this does is bring into Scots law more in line with other jurisdictions and increases the number of remedies that are available. So under the bill, you could order the defender to publish a summary of the court judgment. It allows a settlement statement to be read out in open court, and also enables the courts to order the operator of a website to remove a defamatory statement, and an author, editor or publisher to stop distributing it. And these are all remedies which some people might find actually more useful than money, because it will make it clear that the defamatory statement was incorrect, and sorts that out a bit. In addition, it retains another remedy, which is offer of amends. So it restates the law about offer of amends, which is something that can happen before you get to legal proceedings, where somebody can hold their hands up and say, okay, I shouldn't have written what I wrote about you, so let me say sorry and let me make it better with a statement or whatever. And so it takes it out of the legal forum. But what it does do is also strengthen that particular remedy by making it clear that an offer of amends is deemed to have been rejected if it's not accepted within a reasonable period. So you just can't leave it hanging. You have to get on with it and conclude that. So it really just improves the range of remedies available.
Thank you, Convener.
Shona, then James.
Good morning. A couple of things. You know, obviously one of the issues here for someone wanting to take action is cost, which is very prohibitive for many. And therefore, looking at the area of defamation in the internet age, which is huge, if someone puts something up about you that you feel is defamatory, to pursue that is very costly. One of the issues that may have been helpful in that area is introducing a takedown procedure, which would be a way of someone without necessarily huge cost being able to pursue the issue and have that removed, or at least the poster being required to provide their contact details or agree to the post being taken down. As I understand it, the bill doesn't do that, so it would be helpful just to hear a little bit about why that is. Now, I know that there's a UK-wide review coming, but there's no time frame for that, and it seems to me there is an opportunity here in this bill to strengthen the law more considerably than perhaps is being proposed. So what's the thinking here?
Again, we've followed the Scottish Law Commission's reasoning here, in that they didn't include this in their report in their bill either. We haven't replicated the takedown procedure because really got the potential to contribute to the removal of legitimate postings, and it creates an incentive, in our view, for internet intermediaries to stop requiring personal details when users are registered. And we think it's an undesirable outcome, and it's not proportionate or balanced. And we understand that it's not actually used very much and it's not very effective down south. So there are avenues for people to pursue someone who defames them on the internet, as you know, as well as in print. But we didn't think this was a proportionate response, and we didn't have any evidence that it was really working, which is why it's not included.
Okay. I just think that you're saying about there are other avenues, but as I said earlier, they are very costly to pursue. So if someone doesn't have the financial means and all of that goes with pursuing a defamation case, you know, it feels to me that there needs to be other avenues open to that person without huge financial means to pursue someone. Do you think this bill provides that, or do you think there are other?
I mean, there's the other remedies, the making of amends. You can obviously contact someone who's said something about you and say, well, you know, I don't agree with it, and it could get settled out of court. It doesn't necessarily always have to go to court, but yeah, we didn't think it actually sorted the problem that it was meant to sort. So that's why we've not replicated it.
Do you have any figures for England? Is Wales in the same position as England with this?
Yeah.
Do you have any figures about the number of cases pursued, or so they have at the moment a takedown procedure?
They do, yes.
It might be quite helpful to have.
I can see
that.
if we can find some.
Okay.
Yep, that would be very helpful if you could. Joanne?
If I could maybe add something in addition. I think the main thrust of the bill is to balance the right to your reputation as well as your right to freedom of expression. And I think if we're looking at using the takedown notification service, that is obviously a hindrance to freedom of expression, and means that that's not necessarily done in a way which is in an open forum. It means that an ISP, for example, is simply being asked to do something without, you know, an open discussion, and potentially somebody is having their freedom of expression taken down when perhaps it is legitimate, and it means that an ISP is the person who is having to make this decision. If you say, well, I've been defamed, is that the correct and an appropriate way to do that? And I think the bill is trying to, you know, go towards the freedom of expression side of things, and the takedown notice, as far as I understand, to sort of, you know, reiterate what Jill said, I think it's used very rarely, because the process in actually doing so, in contacting an ISP to get them to take it down, is quite cumbersome.
Don't you see the flip side of that would be where someone can claim freedom of expression, but saying something untruthful and, you know, defamatory about someone, in the full knowledge that the cost of doing something about it is going to prohibit, so they'll just keep doing it, and that surely can't be right.
Well, that is part of the balancing process here. It is quite a difficult balance.
It would be the case now that would be the position.
Yes, but that's why I was asking whether a takedown procedure would help to at least give remedy to someone who's not in a financial position to go to court. The freedom of expression, I understand, but if someone is saying something blatantly defamatory about someone, then I think that is clear when it comes to is that freedom of speech. I'm assuming we're not in agreement that freedom of speech extends to just saying whatever you want about someone, with knowing that there's no consequence to that. And therefore the takedown procedure at least would be a mechanism to be open to someone who doesn't have the financial means to go to court. But I guess this is something that we'll have to pursue. But if you could provide some of the England and Wales information, that would be helpful.
Yeah, I mean, one of the remedies is that you can ask the court to get somebody to stop circulating something or to remove it via
but
that
you have to pay
process
for
as well.
that.
Yeah, but it wouldn't be like going to a court case. It would be applying to the court for an interdict.
But you'd have to employ a lawyer to do that.
Probably, yes.
Yes.
But no, we take your point and we'll certainly try and find out more about that.
Thank you for that. James?
I was going to pursue the same area as Shona, and I very much agree with the points that Shona was making. Let me just kind of tackle it from a slightly different perspective. So, you know, we've all seen the growth of the internet age and social media, and I would certainly submit that although it's a fantastic platform for information and exchange of opinions, one of the downsides of it is that there's been an extension of the ability for people to make defamatory statements without, you know, any kind of proper recourse. So if we're seeing an extension of a platform being used for defamatory statements, and you made the argument that it's about a balance between freedom of expression and people not making defamatory statements, and you seem to be saying that the bill is favoured more in terms of freedom of expression. My concern would be that the evidence shows that the internet has been used to allow people to make defamatory statements without proper recourse, and I think the bill needs to have some proper mechanism in it that's going to restrict people making defamatory statements.
And the provisions in the bill would apply, you know, equally to things that are made on a website or through the internet as they would in print. So the same, you know, balances are there. There might also be other avenues open to people who, it might not be a case of you're being defamed on a website, but somebody is, you know, targeting you with kind of hate correspondence or that kind of thing, and there are other legal avenues for addressing that as well.
So has there been any assessment made of the number of cases or the number of potential cases that exist through the internet, and how what has been proposed would reduce the number of these coming through?
I mean, the available data on defamation cases is, you know, there's very little of it. We know some of the numbers. I mean, the Spice briefing included some numbers about, you know, what cases get to court, but you don't know what never gets there, that's gone off grid. There's very little data available.
And I think that's the real issue. It's the number of cases that don't actually get to court. You know, in just a cursory glance, you can see that this is a major issue, and I think convener will be something that the committee will return to.
Okay. John Finney.
Thank you, convener. James largely covered the point I was going to raise there, and that is about, in picking up and showing us that there are remedies short of going to court and a full court to get individuals to remove defamatory statements. I speak from personal experience. They are costly, but also the availability of appropriate legal advice. Is there any background to that? Is any because it's not every lawyer that's prepared to take on provide advice like this. It seems to be viewed as a bit of a specialism, internet law.
Well, it will be a specialism, and because we don't have, you know, a lot of cases, it's been difficult, I suppose, to build that in Scotland. But you will have heard from some of the specialist defamation solicitors when they came to your round table discussion. They are out there. Some of them did imply that they'll give people advice quite freely, at least initially. So it is there, and the Law Society can certainly point people in the direction of solicitors who have the necessary expertise.
Can also ask in the question of tourism, libel tourism is referred to. Is this likely to have any implications for that?
I think there isn't any in Scotland. It's not seen as an attractive jurisdiction to take a defamation case. There was an issue in England and Wales. Their 2013 Act was an attempt to really address that. So I don't expect, you know, if we go in line with what's more or less happening there and make the other changes, it wouldn't open it up to libel tourism, and there certainly isn't any at the moment that we're aware of.
Okay, thank you very much. Thank you.
Alistair?
Thank you. I suppose it was almost the mirror image of that point that was made there about libel tourism, is presumably, if I just asking this question out of interest, if a Scot defames a Scot online, the defence is not available, that this is on a server somewhere in South America. Presumably there is some thought that has been given to how to enforce these situations where people use that kind of spurious, but no doubt it's an excuse that will be made at some point.
Yes, I mean, just now a newspaper could be printed in England, but it's purchased in Scotland, and if your defamation happens here, you can raise your action here. I don't know if Joanne would be better placed to say anything about that.
Yes, I mean, I think that sort of feeds into, you know, what we were talking about, the takedown notices, where, you know, even if there is a judgment here, trying to get the server in South America to actually get that taken down is going to be difficult. But we're not looking to go beyond the borders here. People are able to raise defamation cases, not only here if they live here, but also if the defamation has occurred here. So if they live in Europe, for example. But, you know, we're living in the difficulty here is that we're living in an international world where we've got particularly the internet, which is a cross-border matter, and it makes it a bit more complicated to try and legislate, particularly for something that's, you know, cutting across that.
Are there any more comments or questions for the Bills team? In that case, can I thank you both very much for attending, and we look forward to dealing with this bill in due course and scrutinising it. That concludes the public part of today's meeting. Our next meeting will be on Tuesday 24th of March, when we'll continue consideration of the Defamation and Malicious Publications Scotland Bill. We now move into private session.